right. So the topic which is coming up now is related to the patents for the digital 2021 artificial intelligence computer simulations G1 oblique 19. And we have our speakers joining in Jaeyoung. He's a head of IP Voronoi. And we have Joginder Singh, partner with LexOrbis IP attorneys. So over to you both.
Yes, I want to mention about yes, the AI, artificial intelligence, and something like the pattern examination guideline for AI. So before that, let me introduce myself again. Maybe it's third time. I'm a patent attorney and IP head of Voronoi. I have worked in Jaeyoung law firm for 9 years, and in 2019, I moved to Voronoi, which is a pharmaceutical company. We, Voronoi, create small molecule drug. One of our core competitiveness is drug discovery and development is speed. We are enhancing those strong points by using of artificial intelligence. In other words, we develop AI-based drug discovery platform and use the same for drug discovery, including generation of chemical compounds, molecular modeling, and prediction. The AI-based drug discovery platform are named as the Voronoi. The Voronoi is an integration platform including AI-based drug discovery platform, molecular modeling, and R&D process management system for the sake of development of small molecule drug. The Voronoi mainly consists of Sci-Hub, which is an integrated machine learning model enhanced by in-house data. And second, advanced molecular dynamics, which is a platform in which the combination of molecular dynamics and structural biology create a synergy effect. And third, R&D process management system, which is web application. So we can say that we, Voronoi, make a step forward in terms of digital transformation. We are advancing drug research and development by interaction among AI, molecular dynamics, structural biology, and web lab in virtue of Voronoi. So everyone, you guys may be familiar with the DT, that is digital transformation. DT is the integration of digital technology into all areas of our business, fundamentally changing how we operate the business. What are the key trends in digital transformation? I want to focus on the better use of AI and machine learning. As we are aware, many companies are utilizing artificial intelligence for their business. For that, they are developing AI technologies and protect the same by patent law. Recently, an Australian court has set a groundbreaking decision. You guys also know the Davos. Yeah, I want to talk about the Davos, the case. So the court stating that artificial intelligence system can be legally recognized as an inventor in patent applications. The AI machine called Davos is a computer system that is programmed to invent. In 2019, two patent applications indicating Davos as the inventor were filed in more than a dozen countries. The Australian Patent Office rejected the patent applications with reason that AI cannot be an inventor. However, the Australian Federal Court determined that an AI system can be named as an inventor on a patent application. The main reasoning for the decision are that, first, the ordinary meaning of inventor does not exclude non-humans. Secondly, AI as inventors promotes the object of the Patent Act. And finally, AI as inventors is not inconsistent with the Patent Act. So let's think that how this affects us. AI system can be listed as an inventor of a patent application. The further, this decision will be particularly important in the pharmaceutical industry, like our company, where AI algorithm or machine learning model is increasingly used for drug discovery. And even though the filing of the patent concerning AI is rapidly increasing, however, the existing examination guidelines in each countries in, fail to precisely indicate clear standard or criteria for judgment. So I want to talk about the story for South Korea. This year, like 2021, South Korea has published an AI examination guideline for invention involving AI-based technology. Here, I would like to introduce summaries of the AI examination guideline, which could be divided into two categories. The first one is written description requirement, and second one is patentability requirement. So the first one, written description requirement. We have to show the concrete means for embodying AI invention. So a concrete means for embodying AI invention, for example, input data for machine learning and data pre-processing method and machine learning model and loss function and so forth should be described. And second, further, the correlations between input data and output data should be described in detail. In this regard, the correlations in input data and output data can be proved by the simulation result. And finally, the patentability requirement, the requisite for invention establishment is this one is mainly identical to those of general invention, in particular computer-related invention. So that is, device or method for processing data or information should be constructed and be described in detail. And inventiveness step. In case that AI technology is just added or an invention is merely systemed by incorporating AI technology, in this case, the invention lacks inventiveness step. So that is no inventiveness. However, inventiveness can be recognized if technical composition for embodying inventions like data pre-processing, machine learning method, and machine learning model, which complete learning, and what is that, like result data are specified in detail. Then finally, they have an improvement compared to the prior art. So in this case, the invention or the AI invention can have inventiveness step. Thank you.
Thank you, Jaeyoung.
Mhm.
Good evening, everyone. My name is Joginder. I am a computer science engineer by qualification, and I'm working as a partner of engineering patent practice with LexOrbis in India. And I'm going to speak about patents for artificial intelligence and computer simulation related inventions. The first slide is about G119, which is a recent decision issued by the Enlarged Board of Appeals of the European Patent Office. This was issued on 10th of March this year. This decision basically deals with the patentability of computer implemented simulations. The board handed down this eagerly awaited decision concerning the patentability of computer implemented simulations. The implications of this decision are far reaching since CI simulations are used to model systems found in wide range of fields including engineering, chemistry, biology, as Jaeyoung mentioned, and even in human psychology. The underlying case of this decision is related to patentability of the motion of people or in a physical environment, for example, in a railway station, in view of the fact that simulated system was not a machine or a technical process or any other technical system. It seemed doubtful that this particular subject matter would meet the EPO's strict standards for technical character, which generally comes into play during the assessment of inventive step. Moreover, many practitioners had feared that the consideration of this case by the enlarged Board of Appeal might lead to a negative determination in regard to the patentability of such inventions. For example, computer implemented simulations, modeling, or even AI related inventions, or any general inventions directed towards a computer related invention. This concern was increased by the fact that before this case was decided, it was generally cited by the EPO examiners as a reason for delaying the examination of inventive step in many EP case files where the invention was relating to a computer implemented simulation or a computer modeling, or even in cases where the simulated system was a technical entity. Happily, this decision is more favorable than the practitioners had feared, and in particular, there is no wholesale exclusion of computer implemented simulations or modeling from patent protection at the EPO. It says that no group of computer implemented inventions can be prior excluded from patent protection, and this is cited in paragraph 139 of the decision. It follows from this decision that it is possible to patent computer implemented simulations and computer modeling at EPO, provided that the claimed invention includes features which contribute to solving a technical problem. The required features might be found in some real world effect produced by the output from the modeling or simulation, but it seems likely that more often the required technical character will derive from an aspect of the implementation of the simulation or the modeling in software or hardware. Notably, some of the implementation details which adapt the computer or its functioning in a way that overcomes the technical problem. It is important to ensure that such implementation details and the problem they solve are disclosed in the specification. Ultimately, the board maintained the legal status quo and deciding that patentability of CI simulations must be assessed on a case to case basis in the same way as any other computer implemented invention. And the established convict approach for inventive step assessment is to be used in every case. Also, the board decided not to define technical, meaning technicality will be decided on a case to case basis, as has been the practice for many years. This means that AI inventions would be treated in the same way very much. I think the main takeaway from this case is that the CI simulation inventions are not automatically allowable or unallowable, while the supporters of patent protection for CI simulations will breathe a sigh of relief that CI simulations can solve a technical problem. They will there is no doubt on the fact that merely pursuing a patent for the technical principle underlying the simulated system or process is not in itself sufficient to establish the patentability. Once again, context is the key, and the examiner will need to be persuaded that a CI simulation invention involves technical consideration. Now, coming to the referral questions and the answers given by the enlarged Board of Appeal. Looking at all these complex questions, the answers given are not really helpful for the applicants seeking to patent computer implemented simulations in Europe. The board has stated that computer implemented simulations can be patented, but they haven't really explained how to decide whether a computer implemented simulation is patentable or not. But the enlarged board's reasoning, which they have given in the decision, that leads to many answers, which will be helpful. And I'm going to discuss some of it in slightly more detail. For example, the board has accepted that a claimed simulation with a direct link to a physical reality, such as step of manufacturing or controlling something based on the result of simulation, is generally sufficient to establish technicality of the simulation steps. But at the same time, the enlarged board has also stated that a direct link to physical reality is not necessary condition, and so computer implemented simulations that do not include such a step remain patentable in theory. The board has also acknowledged that a potential technical effect may be considered if the data resulting from a simulation is specifically adapted for the purposes of intended technical use. In such cases, the technical effect that would result from the intended use of the output data might be considered implied by the claim, but if the output data has genuine non-technical uses, then the technical effect is not achieved over the whole scope of the claim. Therefore, only those technical effects that are at least implied in the claims can be can be considered in the assessment of inventive step. While a direct link to physical reality is not required to patent a computer implemented simulation in Europe, it is still worth including such a feature as a fallback position while drafting patent applications. An implied limitation on the use of the simulation's output data might be sufficient, but we don't know yet how the EPO examiners and the Board of Appeal will interpret this requirement. We only have a small number of cases in which implied limitation on the use of output data is acknowledged, and it is difficult to generalize these cases into drafting practices. Although this will become clearer as and when the EPO will start applying this particular case in the future. Finally, the board's implied limitation approach may be applicable to other computer implemented inventions beyond simulations. For example, artificial intelligence inventions face the same excluded subject matter issues as simulations. If a claimed AI invention doesn't have a direct link to physical reality, applicants may be able to argue for the technical effect based on an implied limitation on the use of its output data. In the end, I would quickly like to discuss some practice points for patent drafting. An implied technical use of a claimed CI simulation confers technicality. Any non-technical users should be excluded from the scope of the claims, and claims should be drafted to refer to the inputs, processes, or outputs associated with a limited technical use. A better running computer while carrying out a CI simulation confers technicality. Claims should be drafted to refer to all of the CI simulation steps that, when executed, bring about a better computer. Technical considerations should be set out in the description. That is, implied technical use or getting a computer to run better. The description should be drafted to explain how technical challenges have been overcome. Any non-technical considerations, for example, business consideration, should be avoided. Otherwise, you are really inviting trouble. Because patent offices are happy to raise a objection for non-patentable subject matter. To avoid possible problems with insufficiency of the disclosure, the implementation of each step of a claim CI simulation should be set out in the detailed description, and the technical advantages associated with each of the steps should be clearly indicated. Thank you. That is it from my side. I have intentionally kept this little short and crisp so that we can have more time for the discussion. Please feel free to ask any questions that you may have for me or Jaeyoung. Thank you.
Thank you.
Thank you so much, Joginder and Jaeyoung. So let me check if we have any questions from the attendees. All right, we have questions from Gerard on the Q&A chat box. So, do you agree with granting Dabber's patent? How much is the AI's contribution to the creation of new pharmaceutical inventions? So, that's the question raised by Gerard. You can also see that question on Q&A tab.
Okay, yes. So the
And
first,
if anyone would like to answer out of you both.
I think Jaeyoung is better suited considering that he comes from the biotechnology and chemistry.
yeah, okay. So the first one, do you agree with the granting Dobbs patent? Yes. In terms of patentability, I fully respect the decision of the patent office, especially the one of the South Africa patent office. And in terms of the issue that AI can be an inventor, yes, I agree with the Australian court decision since this world is the AI-based reality. So we have society. So yeah, the society and the decision should be changed according to the technology. And for the second one, how much is the AI contribution to the creation of new pharmaceutical inventions? Yeah, it depends on the medical use and indication, like disease. When it comes to the drug repositioning, which is to find new medical use for existing drug, I think in this aspect, AI plays an important role. So in this case, AI's contribution is huge. However, for creating new drug, like the first-in-class drug, like HIV or the COVID-19, in this aspect, AI's contribution is not that much since we do not have like much data enough to feed to AI. AI model have to get lots of data to make to result the resultant. But we cannot feed lots of data, so the AI we cannot trust the prediction by AI. So in this case, I think AI's contribution is not that much. And then the last one, yeah, yes. How does the rights of patent is transferred from AI machine to applicant? Well, it is very good question. It is very like subtle and important one. So it is for the assignment. So I think AI cannot assign its right to human or companies in most of the countries. So for example, EPO, the European Patent Office, they do not recognize AI as a successor. So mm, currently, I think the the pet the the patent right of AI machine cannot be succeeded to applicant like a human or companies. But who knows? Thanks to the Australian the court decision, the regulation or patent law could be changed. So I hope AI mhm, I can get assignment from AI. Thank you.
Thank you so much, Jayan, for your input on this particular topic, and also giving the insight on these questions. So, Joginder, if you would like to conclude the session in one line, so what it would be, and
Yes, I would like to say that this is a topic which is evolving, and a lot is happening around the world. Different jurisdictions are implementing it differently. The EPU and the US have rejected the same Davos application which we are referring, but one or two jurisdictions have allowed it, particularly South Africa. So everybody has a different take on this, but very soon we are going to have a consensus on this, and we need to have a uniform guidelines across the world so that the applicants and the inventors have clarity what to expect from such kind of inventions. Thank you.
absolutely. Thank you so much, Joginder, for discussing on this particular topic. And I think that this topic is very much evolving, and we have many more things to say about it in near future. So, thanks, Joginder. Thanks, Jaeyoung, for contributing in this wonderful topic, and thanks participants for highlighting about your questions and also discussing out with them. Thank you so much. Thanks Joginder, thanks Jaeyoung.